Yes, sir.
Yes, I'm fine. I'm here to talk about the solitary confinement. My name is Tyrone Show. I'm an ex-convict myself. I was doing life on an installment plan, 2 years, 18 months, 3.5 years. Then I caught a life bid. In regards to the life bid, I was in and out of solitary confinement. And that's what made me think. Education is the key to freedom. So I got my education while I was in segregation. I got out of segregation. All right, I'm going to piggyback off what the institution said. They give you blankets when it's cold, but yet the blankets they gave you, 2 months after they gave them to you, they're going to come and book you and put you back in segregation for having excess belongings. But that's all irrelevant. In regards to me getting my education, I was in and out of seg. It took me 32 tries to get my GED, and I finally got out of seg and got it. And since I've been out, now the parole board didn't want to give me parole. I was doing life. They wanted me to take responsibility for the crime I was in there for. I couldn't do that. So what I said to them, you got to get a toe tag and a body bag. That's how I'm leaving. Project Innocence took my case. Mike DeLoro, the man I was up here talking, he was one of the people that came to my parole board and got me out on parole. I'm out on parole today because Mike DeLoro was involved with that. But education is a key. I heard Keith, Jose, I heard them all talking about it. Steve, education is what people need, and keeping them locked up 23 hours a day is wrong. Give them that extra time to be out of their cell. They want to go to programs. They want to get the education. And that's the way that you're not going to have them being in a revolving door, going back and forth in and out of prison. I know, because that's what I was doing. It took education to smarten me up, and here I am today, going on 6 years out. I'm working, I got my fiancé, I'm living a good life. I'm happy. And that's what it takes. Give them 4 hours out, but you need to give them the 4 hours out and let them know they got to do a program. In order to be out for 4 hours, do a program. Smart enough, get some kind of education. And that's what I did.
Thank you.
You're welcome.
Take care, Jacqueline.
Thank you.
That's my queen.
This lady right here.
Yep. Pat Quinn. Come on, Pat.
Go ahead.
Oh,
Sit down.
you're on deck, Pat. Go ahead. Go ahead.
My name is Louise. I have a loved one who is currently serving life without parole.
Could you see if that button makes the red light come on? Is the red light on?
The red light's
Okay,
on.
speak right into that microphone.
Okay. My name is Louise. I have a loved one who is currently serving life without parole. My loved one is 73 years old and is wheelchair-bound and will never walk again. All I ask is that he be given a chance to see the parole board. All I ask is that there be a chance for him to not die in prison, not die in a cage. I thank you for your time.
Thank you. Yes, sir.
My name is Trent Manning. I'm here in representing, sorry, here in support of the 568 bill, 5686, sorry, it's late. 5686 bill, the 5149 bill, and going to testify for the 6161 bill, solitary. Basically, I mean, you've heard it all. It's inhumane. It's not enough. I mean, what's happening in jail, no one knows what's happening in jail. We have all these testimonies from all these different individuals telling you what's happening in jail, but still no one's listening. I just don't understand it, honestly. But just to say a simple story of what can get you in solitary, a person sitting at chow. Chow is breakfast, lunch, or dinner. They have a rule of no passing. Now, someone has bread, extra bread on their plate, maybe they're watching their diet. They want to give the bread away. You can go to SEG simply for that. They make this seem like you're fighting, you have a shank. This is Rhode Island. That's not happening over here. It's not New York, this is not Massachusetts, it's not Connecticut, this is Rhode Island. Passing a piece of bread between tables will get you sent to SEG for 10 days. Now, while you're in SEG for 10 days, if you're passing notes, if you're doing the same thing, if you're talking while you're out on rec, if you're discussing, if you're talking to anyone, if you're singing to yourself, you can also get booked. So just to tell you a story from my personal experience, someone passed a piece of bread. This was a Hispanic fellow, didn't know pretty good English. The CO, he's having a bad day. He comes, hey, what are you doing? You can't do that, blah, blah, blah. The inmate goes, oh, okay, buddy. Automatically snaps. Buddy, I'm not your buddy. I'm not your buddy. What's happening? Everyone's looking. What's happening right now? Cuff up. He takes him to SEG. He's doing 10, 15 days. Now, he could get buried down there. That's the slang. You can get buried in SEG. People disappear. You forget they're even still in this building. They disappear into this hole. It's called a hole for a reason. Now, when they come back from this place, they're in Medline now. Their mental state is completely gone. A year later, you're like, oh my God, I had no idea this guy was still here. Their mental state is completely gone. They look shriveled. You know what I mean? Saturday, you get pancakes. In the morning, you get 2 hot dogs. In the afternoon, you get like, whatever, some special Saturday meal. You get 1 pancake in SEG. You get 1 hot dog in SEG. If you get in hamburger, you get 1 hamburger in SEG. I mean, we're talking about torture. Simple. This is not stopping SEG. Yeah, there needs to be something happening. We're talking about reforming. I don't know what's happening today. Why is it even reforming? We're talking about not torturing humans.
Thank you. Yes, ma'am.
I'm sorry. My name is Anusha Ellis. I'm here, a staff organizer with DARE, so I'm representing DARE, Direct Action for Rights and Equality. We're supporting several of the bills that were heard tonight, including the bill to end life without parole, the bill to reform solitary confinement. I want to speak briefly on the caretaker bill 5686 and the bill to end cash bail for misdemeanors 5563. I know that y'all are familiar with all the numbers, the ways in which this is impacting communities generationally, the ways that this is targeting low-income people who are predominantly black and brown people. So I'm not going to get too much into all of that, but what I did want to speak to was the opposition from the judiciary that has been filed against both of these bills, because frankly, I just don't understand why the courts are being given this kind of weight where their discretion is being upheld over matters like whether or not somebody gets bail on a misdemeanor, which is a petty offense. It's something that they're not posing a risk to the public. Evidence from other places shows that people will return for their court dates because nobody wants to get caught up in the court system in that way where they're getting a warrant for a missed court date. There's really no reason for judges to be holding onto their power around the ability to assign people very large amounts of money that they have to pay in order to, like, basically ransom in order to get out. And I just want to speak to our experience working in the courts. Like, we're doing court support every week. We're at the courthouse every week, talking to people, going into the courts. We're going into the courtrooms with people, accompanying them to their court dates. Like, we see how judges are interacting with people on a regular basis. I know some of y'all are familiar with the courts because you work there or have worked there. But for folks who aren't familiar, these judges they're mostly white folks, they're mostly older folks, they're mostly men. And I'm naming those things because many of them are very unfamiliar with the experiences of our community members. And it's very apparent in the way that they talk to folks and interact with folks. So I guess all this to say that I just hope that y'all will keep in mind that you do have the power to limit their discretion, and I think that needs to happen in certain cases. Like, judges should not have unlimited power. They have they're life appointed for life. There's no accountability around what judges are doing. So if y'all do not set these limits on how judges are interacting with our community members, with black and brown people in Rhode Island, with low-income people in Rhode Island, nobody else is going to do it. So that's all I want to say. I just really hope, I appreciate everybody who came out here tonight to share their testimony. I hope that it makes a difference, that folks, are listening. Like, some of this stuff just seems so obvious to me. Like, I just don't understand, like, why people would be asked to pay money as though they pose some sort of risk when they're coming in on a misdemeanor. I don't understand why somebody's parental status would not be considered when we know the impact that it has on children. We know the generational impact. We know this has been happening for decades. I'm done.
Okay, thank you. You guys could step up, and there's 3 more people that want to come forward. Patrick, you're one of them. There you go. Patrick.
Good evening or good morning, committee. I want to thank you all for your patience, and I think the mind can only absorb what the seat can endure. I want to talk a little bit about 6161, and that's the bill on solitary confinement, and this is not on behalf of a client. It's a reflection on what happened with my life. Back in college, I worked in the public defender's office in New York, and it was just an internship. One of the things we did was we'd go to the prison to meet with the inmates. I'll never forget, we had an inmate, and he had the option of going to county jail for 11 months, 27 days, or 2 years in state prison. He took the 2 years in state prison in New York because if he had gone to the county jail, the county sheriff at that point had the habit of putting anyone with tattoos or long hair in solitary confinement for the whole 1127. And it shocked me then and kind of emboldened me to work in the public defender's office later when I moved to Texas. The problem with the bill, and I guess let me get onto the second issue. My son made a mistake, shot someone, ended up in the ACI. He was put in solitary on multiple occasions. And you don't know. You go to visit him. They say he's not coming up this week. Come back next week. But what I noticed in him is when I go back 2 weeks later, he was totally disassociated. He had been in solitary, and he was not a dumb kid. He was an electrician, successful electrician, and he was completely disassociated every time I'd go to see him after he did 3 or 4 stints in solitary, and couldn't talk. He would just sit there and stare at us during our 1 hour visit per week. So I think the bill appears to be a rational approach to solving solitary confinement, coming up with some reasonable boundaries on it. Solitary to me is more akin to torture than it is to rehabilitation. We need to put some guardrails in place. Thank you.
Thanks, Pat. Yes, sir.
Thank you, Mr. Chairperson and respectable committee members, for this opportunity to testify on behalf of House Bill 5149. When I was 18 years old, I committed a crime that I'll forever regret, and I murdered Richard Cowles. And I had some notes here, but the truth is, I was going to speak about what I'm doing in my community. But everything I do in my community and what I did in prison to change was because I owed a debt to my society because of the life I took away. And Richard can't do anything to contribute to society any longer, and I owe it to give back to my community. And it breaks my heart that my release, I was sentenced to life without parole, and I'm only here by the grace of God and the governor that commuted my sentence and gave me the opportunity for parole. But it breaks my heart that my freedom hurt the survivors of my crime. And I'm committed to give back to my community. And I believe in public safety. And the reason I advocate for the end of life without parole is because the best people to stop another crime from happening, from another person getting hurt, is someone that's learned what it is, that has remorse and is vowed to stop crime. I've seen them go back into prisons, people that have survived the sentence of life without parole. They've gone back into prisons. They have mentored youth. They're the ones changing the lives of people in prison so that they won't commit another crime, that they won't create another victim, and that it won't continue the pattern of harm. So I advocate for this bill because the best person to reach people that are headed down that path is people that have been down that path. The sentence of life without parole says that people are irredeemable and have nothing to contribute to society, but as we've heard tonight, that's not true. And I thank you for your time.
Thank you. Yes, sir.
Thank you. Good evening, Honorable Committee. My name is Sam Theo Harris. I'm a resident of Rhode Island, and I'm here today testifying in support of House Bill 6161. On behalf of some of your other constituents who could not be here today, these constituents are those who are most directly impacted by House Bill 6161. Those, of course, are the currently incarcerated. We, as residents of Rhode Island, are going to be reading excerpts from letters from the ACI. Now, let me be very clear. These letters are not from pre-2016. As Mr. Ferruccio had said, that we are talking about only the period before 2016. We are not. They also are not outliers. These were not selected specifically. We've received over 100 letters from the ACI. These were not selected because they were the only instances that support this bill or this sort of initiative. They are not chosen because they show any sort of particularly any sort of particular slant. They are representative of the entire sample.
Before you begin, you're not going to have time. If you'd like to have those letters to be part of the record and have us all digest them when we're a little less tired, you'd be better off giving them to the clerk and then just telling us what it is you want us to do.
Respectfully, we believe that we are honoring the voices of those who would be testifying today.
Respectfully, I'm limiting everyone's testimony to 2 minutes.
Yes, we plan to fall within that.
Okay.
We greatly appreciate the time.
Okay.
We want only to use our voices as residents of people who can be in this room today and who can afford to stay here until 1, 2 a.m. To use that to show that we have seen that solitary confinement in Rhode Island is being used not as a tool. We are told that we should believe that, and if we are to believe that, we have to be able to see it being used as a tool and only as a tool, because the difference between a tool and a weapon often is only how and when it is used. Thank you.
Thank you. Could you provide copies of those for the members of the committee? I'd very much like to see them. We'll give you them back.
Yes, I need to figure out. The propriety of who specifically owns them, I need to figure out, but I will certainly get copies to you if I may.
Okay, thanks. We'll start in the middle.
Okay.
Nice earrings.
Thank you. So I am here for the Ending Life Without Parole. So this is a public apology written by Jose, who is serving life without parole. He is 48 years old and has served 27 years. On February 26, 1993, I made a senseless decision that I have deeply regretted for 30 years. I set a fire that ultimately caused the deaths of 6 innocent members of the Chang family. It is painful to know that 2 loving parents and 4 precious children died because of my reckless actions. I feel overwhelming shame and sadness for my destructive behavior. I have carried the burden of guilt in every breath that I have taken since, and the depth of my sorrow is beyond human expression. One of their relatives, Mr. Ivan Vladimir Ponce, miraculously survived the fire, albeit with serious, traumatic, and life-changing injuries. Being responsible for this horrible tragedy is the most heartbreaking, painful, and regretful decision that I live with every day of my life. I realize that my actions have greatly affected and outright destroyed many people's lives. There is no possible way to ever measure the impact of the loss of an entire family. I put their loved ones through unbearable anguish, no more happiness, just pain, total, endless, absolute pain. I've taken everything from them, everything that ever was and everything that ever will be. No future, no tomorrow, nothing. I'm sorry, Mr. Ponce, for turning your life upside down. I had no right to harm your family. I will never be able to fully comprehend your pain, nor fathom your loss. I've hurt you so personally and so deeply. Our paths crossed as you were in the peace and security of your own home. I have brought incomprehensible trauma to your children, grandchildren, and so on. I am fully aware that no amount of apologies will ever relieve the overwhelming pain, suffering, and loss that I've caused you, but I can't let that deter me from expressing my deepest regret. I am so sorry.
Thank you. Next. Yellow paper.
Thank
really,
you.
And really 2 minutes.
I know. So my name is Elise McCaffrey, and I'm here to testify in support of Bill 5361, which is the bill that would redefine misdemeanors and create the maximum possible sentence for misdemeanors in Rhode Island as 364 days, not 365. I am an immigration attorney, as I mentioned. I provide pro bono legal services to people in Rhode Island facing deportation and applying for asylum, and I can tell you this bill is critical. Number one, it would prevent automatic deportation for people here legally, such as green card holders, student visa holders, and people on employee visas who have a misdemeanor conviction that makes them automatically deportable, even if they have served no time in jail. People with ties to Rhode Island who have families and are part of the community here should not be facing automatic deportation based on a misdemeanor conviction, and this bill, which would drop the maximum possible sentence by a day, would avoid that. Secondly, young people are especially vulnerable to deportation because of poor judgment and mistakes that they may make, which would lead to a misdemeanor conviction. This bill would help young people whose early mistakes could lead to deportation later in life, even after they have fully rehabilitated themselves. Young people often agree to plead guilty without fully understanding the full implications of this plea. This bill would also give some people a chance to ask for release from immigration detention by paying a bond. Currently, some people are completely unable to get out of immigration detention purely because of a misdemeanor conviction. This bill would offer them the chance of release. Other categories of people that would benefit from this bill are survivors of domestic violence and spousal abuse who face additional hurdles to getting legal status because of a misdemeanor conviction in Rhode Island. Immigration law is exceedingly complex, and there are many grounds of deportability and inadmissibility. This bill would not prevent deportation based on all misdemeanors. Certain categories, such as possession of a controlled substance, child abuse, domestic violence, etc., would be exempt. I know we've heard a lot of very important testimony tonight on other pieces of legislation that you're considering. Please do not forget this one. It is very, very important.
Thank you for your testimony. Go ahead.
Hi, everyone. Ju Park. I'm an assistant professor of medicine at Brown. I'll be very quick. I'm speaking in favor of House Bill 5582, and I want to actually talk about alternatives to punishment and incarceration. So, Portugal. I visited Portugal to see what other countries are doing, and the program that they have there is they have a council. So instead of doing all the great things that have been mentioned, you know, providing mental health services, substance use treatment, whatever it is, whatever program it is, instead of doing that inside jail, they're doing it outside. And they're giving free access to a lawyer, social worker, and a medical doctor, usually a psychiatrist. And these types of programs really help reduce burden, you know, reduce the amount of money we're putting into the issues of substance use. I study drug overdose, and I can say that 3,000 people have died in Rhode Island of a drug overdose over the last 14 years, and incarceration increases the risk of overdose by 13. So I just would urge you to support this bill. I also obviously support ending life without parole and solitary confinement. Thank you very much.
Thank you all very much for your testimony. Next three, please. Let's start with Haley. 2 minutes, please.
Good evening, honorable members of the committee. My name is Haley McKee. I'm going to keep this short because I'm generally bugging you every day anyway. I had signed on to testify in support of 7 bills, 5685, 5562, 5209, 5149 rather, 5582 as well. I just want to touch on 6161, which I'm also in support of, and just raise some concerns in this committee while we're here. So, you know, I was part of the package that got submitted on both sides last year of people who were advocating for the bill. While I'm no longer the lobbyist for the Solitary Confinement Coalition, I'm still very much in strong support in what that looked like. And I think it should be noted, during that time for the 2 prior sessions, cars parked around outside of my house, followed. Director of Department of Corrections at the last one, we're sorry that they're following you. Right? My employer during my day job is getting phone calls from the Brotherhood harassing me, right? And what was submitted in the Judiciary Committee on the Senate last year wasn't my disciplinary infractions during my carceral period. It was actually like articles about the car accident that I had had. So I'm not worried about myself. I'm a seasoned, steeled, conditioned advocate who spends a lot of time over here, as you know. I'm worried when we're asking people who are vulnerable and who have survived these things that we're talking about pertaining to solitary confinement to come up here for the first time and are facing intimidation as a result on behalf of people who have tortured them. So I'm asking this committee to keep that in mind, that that's additionally on top of whatever else people have dealt with. They're dealing with that layer in this space. You know, the main reason I'm here today is the lobbyist for the sentencing project on 5149, which is obviously the life without parole bill, and I'm not going to get too into it because I think we've heard some powerful testimony today. I just want to add, one of the things I don't think that's been raised is the lack of educational programming. With that sentence, we're getting letters from people who have been incarcerated for a quarter century who cannot write. So when you have that sentence, you don't get education, and that's been a common theme of what's been working for people. So thank you for your time.
Thank you, Haley.
Good evening.
There you go.
My name is Marina Benson. I will begin by reading a section of a letter from the ACI written by an older gentleman that explains how the conditions of solitary confinement need oversight. In other letters written by this gentleman, he describes the difficulty of getting his necessary medication in a timely manner. He then explains that as a result of this, medical providers have informed him that he may keep some necessary medications in his cell for emergencies. He explains how he has been booked in SEG for this. The letter begins. I was just in SEG and I met the governor's staff that came to Max to see for themselves what is going on. In SEG, one of the gentlemen came over to my cell and looked at my picture and saw that I was a handicapped inmate and I was 71 years old. He was surprised that I was in there for hoarding my high blood pressure medication and having 2 blank cards that I was not using anymore. He says he was not impressed with the DOC, and then I told him that I had to do 90 days ARS, which is the step between SEG and general population. It is still restrictive housing. I will now read a second letter that simply lists reasons that this person has seen for people getting sent to SEG. 1, an officer put an inmate in segregation for only wearing his boxer shorts in his cell while he was sleeping during the hot summer in a building with no air conditioning or central air. 2, an officer put an inmate in segregation for taking a bird bath in his cell during the hot summer in a building with no air conditioning or central air. 3, an officer planted a penthouse in an inmate's cell and then put that inmate in segregation. 4, the prison supplies all inmates with movies that have nudity. However, the prison will put an inmate in segregation or discipline him with cell time if he has a nude book in his cell. 5, inmate told nurse that this is the wrong medication. The nurse then yelled at the inmate, quoting, "She knows what she is doing." After, the nurse found out she had made a mistake, and then the inmate was sent to SEG by the nurse.
Thank you for your testimony. There you go. Red light on, yeah.
Okay. Hi, I'll keep this brief. My name is Angelina Rios Galindo. I'm 19 years old. I'm here testifying in support of Bill 6161 as a member of the Stop Torture Coalition, but also as the daughter of a man who has been reduced to a figure of 9 felonies. He was first incarcerated at the age of 15 and was last paroled the year I was born. I remember hearing stories about his time in solitary confinement, left with nothing but his thoughts, remorse, and ruminating in the treachery of his conditions. Not a day goes by that I don't marvel at the path he carved out of the things he was forced to overcome. But tonight, I'm here to testify on behalf of an individual who, given the landscape of restrictive housing in Rhode Island, may never get the chance to start over like my father did. Shared with us in the beginning of the summer of 2021, this letter starts, I've been in SEG for more than 3 straight years. I was booked over 45 times, mostly for minor infractions, but I at one point was getting the max penalty for everything. My experience was torturous, both mentally and physically. I lost 201 pounds during those 3 years in segregation. I was never allowed to go outside, not once, only if I had court, and that's it. I was never allowed to listen to music, watch TV, nor read newspapers or magazines. How can a human being function in a sane way without music or everyday events of the outside world? I was deprived access to world news. Why? Why are we not allowed to watch, listen, or read recent events? I missed out on 3 years of life, literally. Just imagine yourself quarantined for over 3 years in one little room, forced to eat the same small portions with no music, no calls to anyone except your attorney, no fresh air. Being in segregation made me very antisocial. I trust very little now, especially when it comes to officers, lawyers, politicians, etc. That was sent summer of 2021, not before 2016, just to reiterate. It is trite to say that asking for humane conditions is the bare minimum. The bar is literally on the floor. If folks are incarcerated and thrown into SEG, any chance of rehabilitation is swept under the rug, and the question becomes whether or not they will survive. How can you heal or begin to make amends if you're deprived of your humanity? How can you prepare to return to a life of regular social cues and agency over how you spend your own time? You can't, and it's obvious that that has become the goal. Nearly 20 years later, my father still eats dinner at 4:30 p.m.
Thank you. Okay, who's next? Can we get a quick show of hands? Who else besides these 3? Nick?
Yeah, I'll go after Steve. I got about 10 bills.
You're going to get 2 minutes, period.
Yeah, well, that would be mathematically impossible.
All right.
We'll talk about that later.
Go ahead.
Hello, Honorable Chair Committee. My name is Leo Corso Clark. I'm also here with the Stop Torture Rhode Island Coalition in support of SB 6161. And I'm going to be reading a letter which sort of documents the instances where people were placed in solitary confinement, really outlines sort of the frivolous nature of its abuse within ACI, and sort of in bullet point format. So the first one reads, in segregation, inmates are sometimes given 10 minutes or less to eat, or they will have time added to their segregation sentence. Once I witnessed an inmate disagree with an officer. The inmate asked to see a superior officer. He was not allowed to follow the chain of command, and the inmate was taken to solitary confinement for asking to see a superior officer within the disagreement. One inmate was taken directly to solitary confinement following using another inmate's phone number to call their family. Inmates are often forced to clean contaminated or quarantined cells containing hepatitis, flu, chickenpox, and other serious issues, such as all intimate bodily fluids. Not every inmate has been given proper training on a virus cleanup, and ACI at maximum security does not have the proper safety gear to protect inmates' face or bodies. Neither do they have the correct size outfit for large inmates. If the inmate refuses to do the cleanup and refuses to put his well-being at risk, he will be put in segregation, or they will take his job from them. Inmates are also denied showers directly after blood cleanups or other body fluid issues. The waiting period for a shower is 1 to 8 hours or no shower at all, depending on the superior staff of the cleanup. And if you complain, you are placed in solitary confinement yourself. When in segregation, you occasionally get time out of your cell. If you say that you are going to hurt yourself, or if you have a medical issue, they will put you in a special medical holding cell. You get 0 time out of your cell. It is worse than segregation.
Thank you for your testimony. Right in the center. Go ahead.
My name is Riley Shornack. I'm a Rhode Island resident here to speak in support of House Bill 6161. I have a letter here from a constituent who has experienced solitary confinement. I also have here the inmate discipline history report for this constituent. This is from 2021. So I'll be reading you this constituent's experience in solitary confinement and being incarcerated at Rhode, as well as the official report. Got into a fight, broke a man's nose. I received 40 days seg. Report reads, banging or kicking, assault on an inmate by throwing substances, 40 days disciplinary confinement. Constituent writes, mental breakdown in seg, voices, panic attacks. Something was in my cell. I kicked the door, asked CO to get me out. He said I was just bored. 20 more days in seg to go with the 40. 61 days in seg total. Report reads, banging on door, kicking a cell door, window, or bed. 21 days disciplinary confinement. Constituent writes, state charged for a conversation on the phone, conspiracy to intimidate witness, 30 days seg time. Report reads, any violation of local, state, federal law not specified, 30 days disciplinary confinement. Constituent writes, while in seg on rec, a man on bottom tier flooded a toilet. I am on camera on top tier, never going to bottom, but I still get booked. 21 days in seg to go with the 30, 51 days seg. That man went home the next day. Report reads, conduct that disrupts or interferes with security. 21 days disciplinary confinement. Constituent writes, in my cell, no TV, no radio, bored. I made dice out of toilet paper. Cell search, found dice. I was booked for gambling, 10 days seg. Report reads, gambling, 10 days disciplinary confinement. Constituent writes, booked for yelling out of my cell while in seg, 5 days loss of privileges. Report reads, disorderly conduct, disobeying housing unit or area. 5 days loss of privileges. Thank you.
Thank you. Go ahead.
Good evening. My name is Julian Cohen, and I'm here in support of House Bill 6161. I will be reading a letter from individuals impacted by solitary confinement. The first letter reads, I'm writing you to state my strong support of your new proposed legislation. I've spent the past 3 years incarcerated. During that time, I was exposed to what could properly be termed as torture. Torture as in long-term sensory deprivation that is part of isolation, or DHU, disciplinary housing unit. I was kept in a cell behind the hospital in a 6-cell block. I was only let out for 45 minutes a day, Monday through Friday, not on Saturday or Sunday. I quote-unquote recreated in an 18-foot hallway, at one end of which was a shower. I was kept in these conditions for 25 days, absolutely no sunlight or outdoor rec at all. This was one of my many stays on Torture Lane. During my stay, I grieved the doc. By grieved, I mean filed a grievance on paper, in which I stated the lack of fresh air, sunlight, and human interaction was causing me severe deprivation and hallucinations. Nothing ever came of the grievance. If this legislation could end the future torture of others, it would be a step in the right direction. A second letter reads, I'm an inmate in maximum security, and I wanted to share with you the kind of petty bookings and infractions that we receive in here. These bookings do matter because it can have a negative effect on parole. When they look up your previous bookings, the first thing they see is that an inmate got booked for contraband. Not only parole, but also classification. I've been denied at classification because of a phishing booking while I was in high security. The officer's official report for this individual explains that all inmates have been recently reminded, warned, and advised that such conduct, such as throwing napkins or sugar packets into a garbage barrel, would generate discipline. A third letter reads, I was falsely accused of opening a window, then threatening a correctional officer. I received 75 days in segregation.
Thank you.
Thank you.
Hannah, Steve, Nick. You guys all set back there? Steve?
Nice. Hold on. I'm so tired, my head feels big. I don't know if that makes sense.
Well, it's almost breakfast, so
yeah,
you'll
totally.
get to recharge.
Anyway. All right, you can start the 2 minutes now. Before I begin, I want to note that last year, Richard Ferruccio violated DOC policy and released prison records during his testimony before the Senate Judiciary Committee as part of an ad hominem attack on people who had previously testified on solitary confinement. As a test, I attempted to APRA similar records from the DOC. I was told that releasing those records would, quote, clearly constitute an unwarranted invasion of privacy, unquote, and that these records are exempted from APRA. Also note that interim DOC Director Wayne Salisbury allowed a prisoner under his quote-unquote care to suffer and die of untreated liver cancer and a broken back when he served as warden at the Wyatt Detention Center. Neither of these men should be taken at their word or assumed to be experts on what is or isn't torture. Solitary confinement is torture straight up. Members of this committee know that, and yet year after year, here we are. I implore you all to do better and not discuss how to torture less, but to resolve to not torture at all. And as far as life without parole, when I was a child, I was shocked to find out that the United States of America executed people. Raised Catholic, I couldn't understand why capital punishment was allowed. But I was extremely proud of Rhode Island when I found out we were the first state in the union to outlaw the practice. As an adult, I one day just understood that life imprisonment without the possibility of parole was another kind of execution. It's death by incarceration, a death penalty using age and disease rather than a noose or an electric chair. Again, we can do better, and in the spirit of justice and in the spirit of the state, I implore you to eliminate that final death penalty. Thank you for your time. How's that?
Thank you.
Hello.
Hello.
Nick Corden from Open Doors. I want to first push back about a fundamental misunderstanding about this bill. I've talked to a lot of opponents of the bill, and it actually seems like they don't understand what it does. And it seems like that has not fully been clarified tonight. So just to go back to the basics, the solitary confinement bill would allow for restrictive confinement with only 2 hours out of cell for 15 days. After that 15 days, people could continue to be in restrictive confinement. They would just get 4 hours out of cell. So the statements that were made today by some of the opponents of the bill, that someone could, if there were an 18-year-old who stabbed someone, they could only be punished for 15 days, are patently untrue. And they're actually, because of the sort of refusal to have dialogue by some of the opponents, we've just been unable to get across this like pretty basic understanding of what the bill does. So we're working to get there. To Leo's good question about data, obviously we can't really know what's going on there unless we get clear records. They have a ton of records. The director's response that he might not be able to release some of those records because people have been criticizing Richard Ferruccio for releasing records. Those are clearly different issues. Richard Ferruccio can't release records because he is an employee of the department and he doesn't have the prerogative to make those decisions. The director can release anonymous records to you all so you can provide oversight without threatening or retaliating any of the witnesses. And that's what we need to do. To have oversight, you need to know what's going on. So that seems like a basic first step, and we'd ask that you pursue that. We did have, our coalition, a good sit-down conversation with Director Salisbury several weeks ago. It was the first conversation that the department has agreed to in 3 years. And based on that conversation, I think that it is clear that there is a lot of overlap. The question is not whether or not a bill can be passed that we can agree on, but just the exact nature of that bill. And I hope that we can continue to work together, but that is only going to happen if this committee clearly moves forward, because they're not going to come to the table unless they all agree, unless they know that you are serious.
Great, thanks.
Thank you, Chair and members of the committee, for your time. Before my time begins, if I could just ask a brief question. The ACLU did sign up on a number of bills tonight. I have pared them down to the absolute bare necessities, but I don't think it's feasible in 2 minutes, but I can promise you I'll be as brief as possible, if that is permissible with the committee. Thank you very much, Chair. I do really appreciate it, and I deeply appreciate all of your time tonight. Thank you again, Hannah Stern, on behalf of the ACLU of Rhode Island. I will be brief. I'll start with H5149 and H6139. The ACLU is in strong support of these bills. You've heard so much testimony on it tonight. The legislative findings of these bills really cannot be disputed, as well as that previous testimony. So we will defer to the excellent witnesses that you heard tonight, and we strongly urge support of both of these pieces of legislation. Next, H 5361 by Representative Felix. The ACLU is in strong support of this legislation. We'd really like to thank Representative Felix for her sponsorship of this bill. What this bill would do is redefine in two ways the definitions of felony and misdemeanor in Rhode Island criminal law. That first amendment would address an unfortunate and very harmful provision in state law which makes some crimes felonies even if they carry no risk of a prison sentence at all, solely because they carry a fine greater than $1,000. And under Rhode Island law, this automatically deems that offense a felony. There are a number of collateral consequences, as this committee knows, that flow from someone being designated a felon, such as ineligibility for a number of government benefits, which someone convicted of, for example, of the crime of allowing to be injured any fire hydrant really should not be forced to endure. The second amendment this bill would make would change the maximum prison sentence for a misdemeanor offense from 1 year to 364 days. I will defer again to the excellent testimony that you heard from Mr. Kruger and Ms. McCaffrey on the explanation as to why this is so important. And again, the ACLU strongly urges passage of this legislation. H 5568 by Representative Batista. We will defer to our written testimony for that, but we are in strong support of this bill. H 5686 by Representative Cruz. We just think this bill is compassionate. It's considerate of the importance of a strong familial structure in encouraging rehabilitation and preventing recidivism. And what it does is just prevent the harmful and reverberating effects that incarceration can have on both the incarcerated individual and their children and the family members that the incarcerated individual may be a caretaker for. So again, we strongly urge passage. Moving on to H 5889 by Representative Agello. The ACLU additionally strongly supports this legislation. This bill is just a reinstatement, as Representative Agello noted, of the Comprehensive Community Police Relationship Act, which expired in 2020. But this bill had the critical job of legally requiring the collection of traffic stop and search data, as well as the issuance of annual reports analyzing the data for racial disparities. This bill would statutorily require these acts once again, but this bill also reflects a few things that have become clear to many organizations, including the ACLU, which have worked to address racial profiling since the first traffic stop data collection law was instituted over 2 decades ago. First, that the mere collection of data really just isn't enough, but that it has to be reported in a way that is actually providing better transparency and allowing for public oversight in a very meaningful way. And second, that stronger requirements must be in place to better guide police department responses to racial disparities that are found in their data. And I do want to emphasize that that racial disparities are being found in this data. Drivers of color are being disproportionately stopped. The changes that this bill would make just enhance transparency and oversight. They would put in place a community oversight board for this data, and they would better hold police departments accountable to actually addressing the racial disparities found in their data. We strongly urge passage of this bill. And next is H 6180. By Representative Felix. The ACLU again strongly supports this legislation. This would just increase contact between family members and incarcerated individuals. Again, you've heard so many times tonight that is only beneficial for preventing recidivism and for promoting rehabilitation. And we strongly urge passage. And finally, H 6181. Again, the ACLU strongly supports this bill. You heard earlier that we're one of only 2 states without a state-level certification or decertification process for police officers. It is far past time to enact a law such as this. We know this bill will need to be modified to achieve its stated goal, but we do strongly support its intent just to ensure that the disciplinary results of law enforcement misconduct are being treated the same way, not only as those of every other government employee, but as the hundreds of other professions that require occupational licensure and are subjected to detailed guidelines and professional standards. Police officers who are fired for serious misconduct or convicted of crimes which affect their qualifications simply should not be able to just head over to another department for employment. So we do urge this committee bring Rhode Island in line with the 48 other states which have this process and pass this legislation. Thank you for your time on all these bills. I do really appreciate it. I'm happy to take any questions, or I'm happy to leave you.
Any questions? No. Thank you. Jeremy, you got 6 minutes. You're going to get as much time as her.
Yeah, I appreciate you guys staying here. I'm actually shocked. I stayed here because I wanted to see who was going to be here and who was not. So I commend you guys for actually making yourself present and hearing the testimony. Now, this testimony that I'm going to give is, I'm going to try to paraphrase it and do some more research on some of the testimony that I heard, because I feel like you guys have a major lawsuit on your hands on many occasions. So we're going to start here with Mr. Lombardi, since he started first. 5110. It's the Rhode Island First Step Act. Mr. Lombardi is a chief judge, and we are not in the process right now of even. There's only 5 people on this bill that have even sponsored this bill. This man could possibly be part of your parole board, paroling some of the other bills that we are talking about today, and this is the first step. This step right here is very important, as you know. Not just being the first step, but what I want to break down to you is that this will allow people, it says pre-release confinement for elderly and terminally ill. This bill is important because it's going to save the state a lot of money, and you guys are going to need it. And the reason why you're going to need it is because most of the people that you're incarcerating are mentally ill. Not only during the incarceration, but after. And so the torture that you're doing, and when I get to the torture bill, and I'll tell you what happened to Georgia in 2019, January 9th, when they actually lost their lawsuit. But, so let's go back to this real quick. So it's very important that you handle that issue with the pre-release, and you find ways to adjudicate and remove those people that are already, on their end. So, but the most important bill that Mr. Lombardi brought up was 5115, which would allow expungement for those that are looking to re-enter back into society. This is a very important bill. But expungement does not allow them entry into the field, because what we have, and somebody said that these bills kind of touch like Mr. Cavorsi's bill kind of touch all these other bills. And it's important that we're not just making bills for the employees, that we're making bills for the insurance companies that deny the employee. So there was a gentleman that testified that says he's got all the qualifications, degrees, but guess what? When he actually submitted it, it was no good. And that's because the insurance companies won't insure them. So we need to we need to amend that and make sure that the insurance companies are also not able to discriminate against those that are formerly incarcerated, because it would be irrelevant. Just because you do something substantively doesn't mean that it's actually going to procedurally doesn't mean that substantively it's actually going to be enacted, in real life, in real time. The other bill that I wanted to mention, since I'm not even going to get into to Mr. Edwards' bill. It seemed like it was a pretty good bill. The 5209 bill, of course, I agree. There's a necessity that needs to be done, that we need to find ways to work on the 95% of the people that are getting back out there on the street. I think Mr. Gray gave a great analogy. Why don't you just grab all the people within the 55-mile block or the 55 radius block and drop them off in East Greenwich, or drop them off in, a specific area, and allow them to take care of your children, allow them to mow your lawns, allow them to wash your vehicles, allow them to do the things that you want them to do in this city. Allow them to do that in your home. Maybe cook for your moms or your dad or whatever. Allow them to do those things, and we'll see what happens. I guarantee you guys will act like the people in Warwick and be finding ways to reform the housing and the hotel. You guys will find ways to remove them out of your city. So that is a very important thing. I wanted to talk about, and I wanted to jump to this solitary confinement, because this is a very important bill. But I don't think that anybody has talked about the issue. Somebody touched up on it, I think he was from Massachusetts. He touched up on the fact that we are not incentivizing these people to behave well while they're in there, because there's nothing in there. Somebody talked about, well, education is the way. No, education is the way to the payroll. Education is the way to the budget. That's not going to fix recidivism on a bigger level. What's going to incentivize these people to behave well is that you create programs where they can actually earn their way back to the streets. We have a bill that was put in to give you good time, but we need a bill that is actually going to incentivize them to make money, so when they get out in the world, they're already going to be productive. So this bill that needs to be, if you want to say, addressed with all of these bills, the most important bill that needs to be addressed when you talk about solitary confinement, when you talk about anything that has to do with anyone that's incarcerated, you need to readdress 425610, which is the bill that controls all of those antlers and arms and legs. And that is the director. That is, somebody needs to go in there with a fine-tooth comb and decide what they're going to do, because he's got way too much authority. You guys don't have any authority, and all you do is listen to the testimonies over and over again. I've been here for 3 years listening to some of the same people and their testimonies. I looked at the dates of their testimonies, and they had 2002 dated on their testimonies on the top of the left-hand corner. So we don't want to do that anymore. We want to solve problems, and if you guys are going to get into the business of solving problems, because that's what I'm into, is you're going to start listening to the testimonies of the people and not just like go through the practices because, you know, it's part of the routine. There was a few more bills, and like I said, I'm really ad-libbing on this stuff. But like I said, the solitary confinement bill, this is very important because I wanted to tell you that I was actually reading the newspaper while I was in solitary confinement. I was reading the newspaper when the adjudication came through, when the federal courts reached down on the Reedsville jail in Georgia and decided that this environment that they created in solitary confinement was inhumane and it was constitutionally violating. And the people from inside the prisons actually put the lawsuit against the facility. And you know what they did? They changed the name. And this is what scares me with this bill right now. They changed the name to solitary confinement. So no longer does that affect, no longer is that particular instrument that they use to protect those people in solitary confinement, no longer is that available, because they changed the words to be able to fit their narrative so they could still torture these individuals. And all they did was fix the issues in that particular prison. And then you have all the other state prisons now that are filing lawsuits and following up. So we don't want that to happen here. We don't want you guys to be able to manipulate the words and say, well, we're going to change the word to solitary confinement. What needs to happen is there needs not to be a bill signed for the $52 million until they have adjudicated this lawsuit with the people that have filed against them. They shouldn't be allowed to sign any contracts or anything because you don't know what is going to fall from this lawsuit. And there's going to be some major pain that you have caused. There are people that are filing lawsuits as we speak. And so it's important that you guys review all of the information before you guys just make decisions on these particular issues. I wanted to talk about, no, I'm not going to get cut short because you let a woman testify for 17 minutes. 17 minutes while there were major people walking out. And I understand. I understand. I don't care if it's 3 o'clock. I understand. I don't care. I understand. I respect you guys. You stayed around here. But there were 30 bills put on this agenda. What makes you think that 30 bills can be heard
Jeremy,
properly?
You're not going to raise your voice.
Maybe not. Maybe not. Maybe not. Maybe not. But it's important that you go through each and every bill. Don't put 30 bills on the agenda any longer. Because I'm going to be here every day. I have the time today. I'm not locked up inside. I'm not completely healed, but when I do get healed, I'm going to sue everybody that has denied these people the opportunity to the freedom that this state has guaranteed. And
I know that's why you're here, Jeremy.
This hope, liberty, and freedom. Where is it? Ann Hutchinson came here because she was banished.
Yep.
And people are coming here because you have made it a sanctuary and you're locking them up if they don't walk or look or feel or talk like you.
Can you tell us
Not you, but your laws. You guys are the ones that create the laws, and you have the ones and the ability to change it. And I want to see changes, and I'm not going to leave here. I'm going to sleep here with you guys every single night that you open up the doors. I'm going to be here. I want to see change. You guys are doing a great job, but there's got to be more. And there can't be just exercises. Like, for real, there are so many bills here. And I know all these bills are not going to hit the floor, so I could be wasting a lot of my time as well. So what I'm going to do is put Matt Dawson in a headlock since he's my rep, and now I know who he is. And now I'm going to put him in a headlock. Yes, you're my rep. So we're going to work together, and we're going to get to some places. So you guys will be relieved of a lot of this for right now. So now I know that he's on this committee, and he thinks that he is going to make some change. So I'm going to help him do so. But we need to really go through a lot of these bills because they don't make any sense if you guys are denying them.
How about if we do this, okay? I'm chairman of the committee.
Wonderful.
When we meet Thursday, we'll be in here Thursday, meet in my office at 3:30, and we'll discuss the bills for the remaining half an hour before we take the floor.
Every single bill that's on the list, because there were bills that are on the list for tomorrow too, if I'm not mistaken.
I'm going to finish what you want to finish now. I'll take that half an hour on Thursday, okay?
All right.
Meet you in my office.
That'll be perfect. I'll be more prepared. See, this is the problem. This is the problem. You put people on a time limit when they come up here at the end. Yeah. You don't do that at the beginning. So when people come up here, they feel all scattered. Mm-hmm. That's a problem. So what you should be able to do is you should make those correctional officers and those people that are getting paid to come here, you should put them last and put those people that don't have the ability to really be here, allow them to testify first. Allow them to get the full room. Allow them to get all the ears. Well, it's very important.
We can talk about that on Thursday, but I can tell you what I did tonight and I've done for the last 5 years that I've chaired this committee is I conduct every meeting to the best of my ability. And if I make the wrong choices, then I have to live with them. But I'm more than happy to listen to your criticism and suggestions.
This is not criticism. See, there's a difference. You could say it's a critique, but I will tell you this. I'm going to come fully prepared on Thursday to sit down with you, Mr. Dawson, Mr. Baptista, and Mr. Knight. Those are the 4 people. She's done a great job. She listens. Her eyes are open. No, you walk around too much, to be honest. And this is Mrs. Cruz was there the whole time. I know that. I appreciate it. I appreciate it.
See you Thursday.
I'll see you Thursday.
Yeah. All in favor?
Oh, no, hold on. On Thursday, this was the most important part, and you guys had it underneath all my... I want you guys all to read this book. It's called Punishment and Profit: How America Criminalized the Poor in the Name of Justice. It's by Tony Messenger. Somebody talked about St. Louis. He's from there. He was part of the Ferguson. He wrote about Ferguson, and so we need to talk about this book in its entirety, and we're going to go through it.